Welcome to the Bar Exam Toolbox podcast. Today we have another in our Listen and Learn series. This one is on professional responsibility. Specifically, today we are going to talk about the ethical rules governing the supervision of attorneys at a law firm. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess, that's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. For the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta, Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox Podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Today we are going to talk about the ethical rules governing the supervision of employees at a law firm. This is an issue that might be part of a fact pattern involving professional responsibility on the California Bar Exam, or it could show up on the MPRE. The rules themselves are not difficult to understand, but sometimes can be tricky to apply because they are so fact-dependent. While there are slight differences in the verbiage, the two versions of these rules in both the ABA model rules and the California rules have virtually the same meaning. So let's start with the rules involving attorneys who are associates of a firm and are often supervised by more experienced attorneys or partners. This rule addresses the role of supervisors. ABA Rule 5.1 provides A partner in a law firm and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. B. A lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct. C. A lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if 1. The lawyer orders or, with knowledge of the specific conduct, ratifies the conduct involved, or 2. The lawyer is a partner or has comparable managerial authority in the law firm in which the other lawyer practices, or has direct supervisory authority over the other lawyer and knows of the conduct at a time when its consequences can be avoided or mitigated but fails to take reasonable remedial action. So let's consider how this rule might be used on the bar exam with the following facts. Attorney Alex hires newly licensed lawyer Louis to help him with some of the more mundane parts of his property law practice. Alex tells Louis to take a set of lien documents completed by a former paralegal in the office who just quit, or was fired, and to review them for accuracy. If he believes they are accurate, Alex tells Louis to go ahead and sign the attached documents certifying their accuracy, but not to spend more than an hour on each document. In an effort to avoid cutting into his own billable hours, Alex tells Louis he should resolve any legal issues he is concerned with on his own, as Alex is very busy with a high-profile litigation matter. Has Alex violated any ethical rules in how he instructed Louis to complete this task? While we know from the rules addressing competence that any attorney may take on a task he or she is not experienced with, as long as there is an intent to become competent before completing the task, the question posed here asks a slightly different question, not whether Louis is willing or able to become competent in this particular area of the law, but instead whether Alex has met his obligation to supervise a new attorney he has employed and knows is not yet experienced enough in property law to complete the task. The answer is that Alex has violated Rule 5.1 because he did not commit to adequately supervising Louis's work before it is submitted as completed work for the client. Again, under Rule 5.1b, Alex has direct supervisory authority over Louis and shall make reasonable efforts to ensure that Louis conforms to the rules of professional conduct. Alex knew Louis did not have any previous experience with property law and was just newly licensed. Alex's instruction to Louis could be viewed as encouraging Louis to violate Rule 1.1 on competence, even if Louis takes the initiative to actually learn about what he is doing on his own. Therefore, by using the excuse of being too busy with his other work, Alex is not adequately supervising Louis and could be in violation of Rule 5.1. What if we considered the duty of supervising subordinate attorneys from a slightly different angle? Rule 5.2 addresses the duty owed by a subordinate attorney who completes a task at the direction of the supervising attorney. Depending on the particular facts of a situation, the subordinate attorney may not be able to always avoid responsibility for their mistakes. Under both the California and ABA versions of the rule, Rule 5.2 provides: A. A lawyer is bound by the rules of professional conduct notwithstanding that the lawyer acted at the direction of another person. B. A subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with a supervisory lawyer's reasonable resolution of an arguable question of professional duty. Now consider the following fact pattern. Larry is a partner in a law firm and is involved in a very contentious lawsuit on behalf of a Fortune 500 company. The firm has just received a discovery request from a former employee suing the company for age discrimination. They are looking for a specific document containing a discussion about an email sent by a department head who is blaming the employee's age for not being able to keep up with some of the technological changes. The document may have contained some information from the company attorney who provided advice about the situation. Larry asks Amanda, a first-year associate, to locate this document in some boxes the company just sent over in response to the discovery request. Amanda locates the document and brings it to Larry. Larry tells Amanda to place the document in another file containing privileged documents. When Amanda questions whether a copy should be put back in the box, Larry responds that it was misfiled. Larry then tells Amanda to prepare a response to the discovery request, saying the document contains privileged information and will not be provided in discovery. Amanda questions whether the document is actually privileged, but is also concerned that if she does not do as Larry asks, she might not receive a good review. If there is actually some question about this document, is Amanda subject to discipline under Rule 5.2 if she completes the task as Larry requests and it later turns out the document is not privileged? Now, if in fact Larry is not intentionally trying to hide a document the opposing party is entitled to receive in discovery, but is protecting a document that might be protected by some form of privilege, Amanda would not be subject to discipline if she completes the task as requested by Larry. The key here would be if Larry's instruction to Amanda is a reasonable resolution of a question of professional duty. Protecting a privileged document is a valid reason to withhold a document requested in discovery. While Amanda may not be certain this is the correct result, as long as Larry's direction is a sincere attempt to protect a document he believes is protected, her completion of the task should not result in discipline. Finally, yet another rule addresses employees of a firm who are not attorneys, but who still require supervision. Again, the ABA rule and the California versions of the rule do not differ significantly. Rule 5.3 provides, with respect to a non-lawyer employed or retained by or associated with a lawyer, A partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurances that the person's conduct is compatible with the professional obligations of the lawyer. B. A lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And C, a lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer if 1. The lawyer orders or, with the knowledge of the specific conduct, ratifies the conduct involved, or 2. The lawyer is a partner or has comparable managerial authority in a law firm in which the person is employed, or has direct supervisory authority over the person and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. So let's now consider how this rule might appear on a bar exam essay. Consider the following fact pattern. Attorney Alice has tried to build a very efficient law practice by hiring experienced paralegals and legal assistants who received certificates from some of the best local colleges. Alice believes this reduces the need to micromanage their work, but allows her to still feel confident that these employees know how to best complete their assigned tasks. Recently, one of Alice's legal assistants, Linda, misfiled a client matter, resulting in the case not being filed before the statute of limitations expired. Linda has worked for Alice for many years and understands the guidelines Alice has set up for filing and tracking client matters so that important dates are properly calendared. Linda simply made a mistake. Is Alice subject to discipline for Linda's error? You may be surprised to learn that Alice may not actually face discipline for Linda's mistake. The applicable standard is found in Rule 5.3b, which states a lawyer who has direct supervisory authority over a non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. Therefore, unless there are facts that Alice failed to supervise her employees adequately, she will not likely be disciplined for Linda's mistake. But remember, although Alice may still face liability to the client whose matter was not filed in time through a malpractice action, discipline from the bar is not a necessary part of that civil action. And that's all we have time for today. We hope you found these hypos to be helpful examples of how to work through questions concerning subordinate attorneys and staff. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or Alison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.